Hello, I'm Roun McNeal, Instructional Assistant Professor of Criminal Justice and Legal Studies at the University of Mississippi, and this is the lecture series for Ethics in the Legal Environment. We are continuing to examine the ethical duties of lawyers. If you've ever been entrusted with a secret from a friend, you have some sense of the fidelity that goes along with that secret. You also know the temptation to divulge the confidential information. A lawyer's duty of confidentiality has some mystique around it, probably why it's the most well known of fiduciary duties. Before we dive into confidentiality, let's quickly review where we've been. In the last unit, we covered duties of competence, diligence, and communication. They are less sexy than confidentiality, but no less important. In this unit, we will learn the difference between this duty of confidentiality and another concept you have probably heard of, attorney-client privilege. These are often used interchangeably, but they are distinct concepts with distinct applications. We will also discuss how some things are not protected by confidentiality or privilege. We'll discuss what happens when, as sometimes happens, a lawyer unintentionally discloses confidential information and what role a paralegal plays in maintaining confidentiality. First, let's establish the difference between the duty of confidentiality and the attorney-client privilege. The duty of confidentiality is a general rule promoting security in the relationship between the client and his lawyer so that nothing will be disclosed without the client's consent unless absolutely necessary. This promise of confidentiality incentivizes clients to disclose damaging or embarrassing but necessary information for good representation. For lawyers to represent clients effectively, they need to know the full story. For example, in my days of private practice, I represented some domestic clients who were either going through a divorce or trying to modify child custody or support. These matters are usually extremely personal and demonstrate some of our most embarrassing human flaws: infidelity, difficult relationships with children, or money struggles. There are details you don't want to share with anyone. However, in my experience, sometimes my client's ex was more willing to share secrets about my client with her lawyer than my client was willing to share with me. A client is put at an extreme disadvantage if he doesn't trust his lawyer enough to tell him up front that his ex may accuse him of cheating with the babysitter or of abusing the children. But confidences are not just admissions to misdeeds. Confidences are any communication made to the lawyer by the client which the client intends to keep private. This could be anything from the amount of the fee that the client has paid to even the existence of the attorney-client relationship. Your client may not want anyone to know that she has hired a lawyer. Whatever the client intends to keep private should be kept confidential. So how is one to know what all the client intends to keep private? Well, it's best to err on the side of caution and just not talk about a specific client's case details. Consider it as an expansive duty, one that begins even from the initial consultation. Lawyers who teach this subject have used the following hypothetical for years. Imagine a stranger bursts into your law office and exclaims, "I need a lawyer. I just killed my wife." Is that statement covered by the duty of confidentiality? Well, yes. There may be some extenuating circumstances or additional facts that provide some exception permitting disclosure, but as a lawyer, your ethical obligation is to keep the confidences of a client or even someone seeking legal representation. The duty of confidentiality is an absolute prohibition against the attorney's disclosure of any information gained about his client, regardless of the source. In some ways, the duty of confidentiality is more expansive than the attorney-client privilege. So then, what do we mean by attorney-client privilege? Well, the privilege is an evidentiary rule that protects some classification of information from mandatory disclosure by law enforcement or the court. Attorney-client privilege prevents the prosecution from forcing a lawyer to testify against his criminal client or from using statements a client told his lawyer in confidence from being used against the client. Frequently, in fact almost always, a statement made to a lawyer by a client will be covered by both the attorney-client privilege, which prohibits the statement from being used as evidence against the client, and covered by the duty of confidentiality, an ethical rule which, if violated, will bring down ethical sanctions upon the lawyer. So this is the key distinction. Attorney-client privilege is an evidentiary rule used to determine what evidence can and cannot be used in court. The duty of confidentiality is an ethical rule that is broad and expansive, prohibiting not just disclosure to courts or law enforcement, but to anyone. And so there are more concrete elements to an assertion by the client of attorney-client privilege. The privilege must be affirmatively asserted by showing that the person asserting the privilege sought to become a client and made the communication to an attorney or staff member for the purpose of seeking legal assistance without the presence of a third party. To demonstrate the difference between the two, think about this hypothetical. Hal and Winifred are getting divorced. Hal has been secretly transferring property he owns personally into a company he owns with his new girlfriend in an effort to keep Winifred from getting it in the divorce. Hal doesn't even tell his lawyer about these transfers, but his lawyer finds out because they are publicly available at the courthouse. One night, Hal's lawyer is loudly talking in Barrister's bar after a few drinks about his client hiding assets in the divorce. It just so happens that Winifred's lawyer is in the bar, and Winifred finds out about Hal's dirty tricks. The lawyer's discussion in the bar may not be a violation of attorney-client privilege. The lawyer isn't giving testimony about a privileged communication between himself and Hal. Hal never even told the lawyer about the deeds. But Hal is disclosing information that he learned about his client and violating the duty of confidentiality. At the end of the last unit, I called confidentiality Gandalf's rule. Keep it secret, keep it safe. But let's round out this lecture with 2 reasons a lawyer might disclose information that might otherwise be confidential. Confidentiality can be waived, and in some cases, attorneys might be required to disclose otherwise confidential information. Waiver of confidentiality occurs when the client either explicitly or implicitly authorizes the disclosure of information obtained by the attorney. Just as a client owns the representation, the client similarly owns the protected information. A client can explicitly authorize disclosure, perhaps through a signed waiver. For example, it's common for attorneys who handle adoption cases to have their clients, the adopting parents, sign a waiver form that authorizes the attorney to discuss the adoption with the adopted child once the adopted child reaches the age of majority. Otherwise, to talk to the child, who is not the client, would violate confidentiality. Waiver is implicit if a lawyer must disclose in order to comply with the law. A court order to disclose otherwise confidential information would pierce the duty of confidentiality. Finally, disclosure to a third party can assume waiver of confidentiality by the client. Third parties, though, will not always break confidentiality. Consider the case of Kevlik versus Goldstein, in which an attorney met for an initial consultation with a business associate's son. Now, the son wanted to sue the town of Derry for police brutality. The attorney quickly realized that he represented the town's insurance carrier, who could possibly be a party to the lawsuit, so the attorney declined the case. The son went out and got a new lawyer, and that new lawyer moved to disqualify the first lawyer from any participation in the case because he had met with the plaintiff's son and owed him a duty of confidentiality. The attorney claimed that the presence of a third party, specifically the father of the plaintiff, during the consultation operated to destroy the privilege and the duty of confidentiality. The court disagreed. Communication between attorney and client remains privileged and confidential where the third party is present in such a capacity as to be identified with the client. In other words, the father was acting in a supportive parental role when his son divulged confidential information during the consult, and the son could have reasonably believed that everything he said to his lawyer in front of his father would remain confidential. The confidentiality also attaches to staff members in law offices. Clients often meet with paralegals primarily without attorneys being present. Clients have to be just as comfortable with paralegals as with attorneys when sharing sensitive private information. Staff are a professional extension of the attorneys, and attorneys must keep confidential information shared with staff members. This is illustrated in Commonwealth versus Knoll, in which statements made to an independent contractor for the purpose of trial preparation were both privileged and confidential. Another concept to consider is the common interest rule. Similarly to how law office staff must keep confidences between themselves, sometimes law firms cooperate with each other on cases where their clients' interests are aligned. So, communication between one law firm and another law firm discussing joint strategy for their clients, that's protected by attorney-client privilege. In addition to waiver of confidentiality, there are circumstances when disclosure of otherwise confidential information is either required or permitted. Certain circumstances may lead an attorney or staff member to disclose confidential information. Permitted disclosures refer to the right of an attorney to reveal, even without the client's consent, information that he or she learned from the client in certain cases. One example of this permitted disclosure is the limited authority to reveal information that would prevent death or serious bodily injury. Imagine if your client in a divorce case called and threatened to burn down the marital home, saying, "If I can't have it, neither can she." The threat of future criminal conduct is protected by neither the duty of confidentiality nor the attorney-client privilege, as we will discuss more when we talk about the crime-fraud exception. What if a paralegal comes across confidential information that could prevent death or serious bodily injury? Well, as we've already established, lawyers' duties of confidentiality extend to the staff. How can paralegals deal with permissive disclosure? Well, if time permits, paralegals should bring the information to the supervising attorney to make a decision about disclosure. But if no time permits, a paralegal may have to decide to report otherwise confidential information to appropriate authorities in order to save a life. Whether paralegal or lawyer, the law office has to weigh some factors before disclosing. How serious is the potential for injury or harm? How imminent or immediate likely is the harm? Is there any alternative means besides disclosure to prevent the harm? And has the client attempted to involve his attorney in a crime? If the law office does not choose to disclose information that might prevent serious injury or death, the lawyer might be compelled to do so by a court order. Let's finish the lecture by talking about two circumstances that require disclosure: furthering a client's criminal enterprise and anticipating perjury. When a client who is a criminal defendant uses his attorney to advance his criminal enterprise, the lawyer should make a disclosure to prevent assisting in the commission of a crime. This is called the crime-fraud exception. The court can compel disclosure of information contained in a communication that was itself in the furtherance of the crime or fraud. It cannot be merely that it has the potential of being relevant evidence in criminal or fraudulent activity. The exception is prospective. A lawyer cannot break the privilege or confidentiality and talk about a crime that has already been committed and consummated. If the crime is over, then the attorney is not taking an active part in it. The attorney is now an advocate trying to help the client find the best result. However, if the state can prove that the client was engaged in criminal or fraudulent conduct when seeking counsel and that the attorney's assistance was obtained in furtherance of the criminal or fraudulent conduct, then the privilege and confidentiality can be pierced. Finally, lawyers may be required to act if they anticipate a witness's perjury. Perjury is a witness's knowingly false and willful assertion as to a matter of fact, opinion, belief, or knowledge material to an inquiry made under oath in a judicial proceeding as part of his or her evidence, also known as lying under oath. If an attorney has a reasonable belief that his client will not tell the truth when under oath, he is ethically prohibited from affirmatively offering that testimony in court. In other words, a lawyer cannot put his client on the stand and ask the client questions if the lawyer reasonably believes that the client will lie in response to those questions. So, what are the lawyer's options? First, the attorney ought to attempt to convince the client not to lie by explaining that subordination of perjury violates both the law and the canons of ethics, and that the lawyer is required to disclose known perjury to the court. With enough lead time, the attorney may petition to withdraw from the case, so that the client may have another lawyer who presumably will not be as burdened with the truth. A third option is a middle way called non-sponsored testimony. Non-sponsorship of testimony is allowing the witness to testify in a narrative style without asking questions or participating by the attorney at all. The theory goes, if the attorney is not asking questions and participating in the testimony, that he is not suborning perjury. But that's a pretty thin line. Keep it secret, keep it safe. That's the theme for protecting the confidentiality of the client. But what happens when that confidentiality is broken? In the next lecture in this unit, we will address unintentional disclosures and implications for paralegals, as well as looking at a few cases that help illustrate these concepts. Until next time.